Start. Mr. Deputy Chairman, this small measure, which I thought would not take much time, has been debated upon with a certain amount of interest and enthusiasm. Criticism has been twofold. One set of honorable members who have participated in the debate have put forward the thesis that this is much too drastic a measure and that it cuts at the root of the rights of the landlords in regard to the eviction of tenants which they have been enjoying under the provisions of section 13 of the Rent Control Act. Very lengthy and elaborate arguments were advanced, some of them legalistic, and a case has been sought to be built on the ground that great hardship is likely to accrue to the landlords if this temporary relief is granted as contemplated by the amending bill. Then, sir, there has been another set of speakers, some belonging to the benches opposite and some to this side of the house, who have supported the measure so far as it goes, but have further taken the line that it does not go far enough and that it should be made even more stringent. If I may respectfully say, that is some justification for the present measure in the form in which it has been brought forward. These violent reactions, one way or the other, do indicate that there can be a violent difference of opinion and difference in approach when dealing with a problem of this nature, and from the very nature of circumstances, a certain amount of balanced approach has to be brought about so that the hardship to which the tenants may be exposed may be minimized, and at the same time the genuinely difficult cases of landlords may not be covered by this temporary protection. An effort has been made to strike a mean of that nature when this bill was drafted and brought forward before this honorable house. The argument that has been put forward by the set of honorable members whom I may describe as pro-landlord group has been that under section 13 of the Parent Act, after obtaining the decree, the landlord will not be entitled to execute it, or if he brings forward a suit, he will not succeed, and that would lead to a great deal of hardship to the landlord. All types of arguments have been advanced in support of that view. Various clauses have been examined at considerable length by two very experienced parliamentarians. They have posed a question and asked for justification of this temporary relief with regard to the cases which are covered by those clauses. The basic fact which is to be remembered while examining a provision of this nature is the practical human side along with the purely legal side. After all, it is not the government's case at the moment that a case has come for doing away with the various clauses. Stop.